Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I
see,
earnestly request your Lord.
but we are, since beyond those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that these 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the house? Prima facie, at least, for him.
Now, my lord, let me show the judgment of the High Court which was dealt with by Bomai judgment. Your lordships, my lord, very right concern, my lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your lordship in Bomai did not accept that rejection. Kindly, my lord, allow me to place, my lord, that High Court judgment, my lord. Because when we cite Bomai, my lord, we generally don't see the High Court judgment, my lord. Kindly see, my lord, para 32. And this would be, my lord, an answer. And, my lord, please, again, my lord, I am requesting, please examine the law as agnostic of the facts right now. And thereafter, my lord, I will assist your lordship on the facts. What is the law? What is the power of the governor? What are the contours of power? What are the limitations? Lord, please come to para 32. Lord, this can be, my lord, my answer. May I read, my lord? Your lordships have got. Mr. Soli Sorabji also contended, this is his argument before the High Court, my lord, that the factors like alleged unethical methods adopted during the formation of Janata Dal, expansion of cabinet, horse trading and atmosphere getting vitiated are not only vague but have no rational nexus at all. The question of failure of constitutional machinery, the learned counsel also laid, my lord, kindly come down, my lord, anti-defection law, my lord, it says, I'll just read fully. The learned counsel also laid great stress by contending that governor, by acting upon the letters given by 19 legislators, had circumvented the anti-defection legislation, the primary aim of which is to discourage the toppling game by legislators by changing their loyalties, and by acting upon those letters, the legislators were permitted, in substance, to play the game of toppling the ruling party, ruling ministry, without incurring the consequence of anti-defection law, because if these legislators had withdrawn their support in the House and voted against the ministry, they would have incurred disqualification under anti-defection law. Reliance upon these letters is contrary to the underlying purpose and the essence of anti-defection legislation, and therefore illegitimate and prohibited. Kindly mark this. The learned counsel buttressed these arguments by contending that if the floor test had been held, the legislators would have written letters, who had written letters might have changed their mind for several valid reasons, i.e., change of the style of functioning of leadership, change in the leadership, realization for maintaining party unity, unwillingness to incur disqualification under anti-defection legislation, and 5, not giving a pretext for imposition of precedence rule. In support of the contention that the floor test has always been recognized as the legitimate and relevant method, Sri Sorabji relied on the judgment of Orissa High Court so-and-so, so-and-so. Lord, he was insisting that please allow floor test, because that's what the law says is the only test That's what we call dance of democracy is on the floor of the house, not outside. And the governor cannot go beyond a particular point. This was rejected by the High Court, my lord, at para 54. 34. Page 2475. Mr. Sorabji had made pointed reference, this is the finding of the High Court, pointed reference to the 10th schedule, i.e. anti-defection law for the bringing home his point that factum of withdrawal of the support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in the context of anti-defection legislation, floor test was the most relevant, legitimate and surest method to determine whether the Council of Ministers headed by Sri Bomai commanded the majority in the House or not. We are afraid we are unable to agree with this submission of the Learned Council. The introduction of 10th schedule in the Constitution has not in any way affected the exercise of powers under Article 356, nor has it amended Article 356 in any manner. The amending body which inserted the 10th schedule to the Constitution had before it the several decisions, especially the Rajasthan case as to the scope of Article 356. There is a presumption that the lawmaking body was aware of the existing interpretation, and the court said that no, he should have kept Schedule 10 in mind while exercising powers under 356. Now, my lord, please see how Bomai judgment deals with this. Lord, it was pointed out that para 397, my lord, was read out of context, my lord, to show. Lord, kindly see, Lord, Bomai is, my lord, JC volume 2, PDF page 516.
516?
Yes, my lord. Your lordships, my lord, in the judgment of Justice Jivan Reddy, my lord, a special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my lord, the court, my lord, thereafter records, my lord, 397. In this context, my lord, the court examined this, my lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. And that in that context, my lord, 397. Please see, my lord, 397. May I read? We are equally of the opinion that High Court was in error in holding that enactment or addition of 10th schedule to the Constitution has not made difference. The object of 10th schedule is to prevent and discourage floor crossing and defections, which at one time assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in case of split, a legislator had to support his party willy-nilly. This is the difference between the position obtaining prior to and after 10th schedule. Prior to the said amendment, the legislator could shift the loyalty from one party to the other any number of times without imperiling his membership of the House. It was as if he had property in the office. That, my lord, in that context, the request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. Take step under 174 and 175. That's what precisely the governor has done. And, my lord, a similar situation arose. And, my lord, now I will read your lordships, the judgment in Shivraj Singh Chauhan, where all this is considered. But before that, please come to para 7 of my propositions. There are more than one reasons, my lord. Why, my lord, this cannot be the argument of the petitioner, and I'll demonstrate, my lord, what is the flip side of this argument. If your lordships, my lord, were to hold that governor cannot examine the inter se dispute, or he waits till the speaker decides disqualification, what is the flip side? I must, my lord, assist your lordship with that flip side. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing floor test, since it is possible that the original political party of the members of the House may condone the defiance of the whip as contemplated under para 2(1)(b) of the 10th schedule. Lord, kindly pause here for a minute. Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, so there is a provision that the party may condone it within 15 days. So, governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction, the government has lost majority, there are attacks taking place, there is vandalism taking place, threats being administered, then I'll not wait for 15 days. Because party may.
Mr. Solicitor, there are
Lordships are examining proposition.
Right, there are two different distinct things. One is a dissatisfaction within a party, right? And the other is a loss of majority of the government. One is not necessarily indicative of the other.
Correct.
Now tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, my lord, only, my lord, one thing, my lord, kindly bear one.
Only one.